I'm willing to do this on my own. But even that can't be done because my witnesses, I have to get from them, and they're not giving me anything.
Well, your
That's why-
witnesses you have to get from them. What does that mean, ma'am? Do you know who the witnesses are?
Yes, ma'am, but
Okay, well,
to
the
get
court can,
names,
you need names of witnesses?
I have these names and all these things, and I have asked Miss Barr for them. I have asked her for the name of the flooring company who put this down. I'm not just trying to, I took this to small claims facility because she put it on my credit report, which I was starting to do well. And by her doing that, she waited all these years. And I constantly asked her for my deposit, which she had 30 days to either give it to me or tell me why she did.
Okay, so all I have here, let me just go backtrack here on this claim. I do see where this was transferred from our small claims division, that you filed a small claims action, said false information on credit report without judgment. Plaintiff is still holding deposit. Is this from a landlord tenant matter or something?
It was at first, but it was never like that. When they took me to court, and the judge asked them how much did I owe, and they told him nothing, because I owed nothing. And they took me for excessive calling the police. He asked them why I keep calling the police. They wouldn't answer. I told them why. Because they have stolen tens of thousands of dollars from me. I have over 200 and something police reports that I keep trying to get that I still have not gotten. And the one that I did get was so redacted. Everything was blacked out. I'm trying to get the name of this flooring company that they have a contract with US Flooring Company, but they deliberately went to an outside contract to put a floor down that was filled with asbestos. I am sick, I am dying. All because her and, as she called them, her guys.
Okay,
And I've been trying to get lawyers, I've been blocked, I've called governor, I've called every state official, every city official. I've been blocked from everything. And if I get a little closer and trying to get a home, it is snatched up on me. I'm homeless now because of all this. And they keep me homeless. I'm supposed to get an apartment February the 1st. If I come anywhere close to this today, I guarantee you February the 1st, I will not have that apartment. Legally, I should be living at Stadium North or Baywood or any one of these I've applied for. I have dealt with city officials, state officials, politicians. I spoke with Debbie Kavanaugh, Bill Dan Kildee. These people have called me, and I am, if anything comes, this is way bigger than you think, because it's not just about that. But I'm sick, and I don't care about what they're doing. Because everywhere I turn, they're stealing from me, and it's being blocked. I go to get help. So what? I call the law. I had a hole in my head that should have a plate over. And I can't even get help from doctor's hospital. I won't even go.
okay, ma'am, we're not gonna talk.
I'm
apologetic that you're dealing with any health issues, but I'm not here to talk about
Yes, ma'am.
what the doctors should or couldn't do. That has nothing to do with this particular case. You filed a lawsuit in here that was transferred from the small claims to general civil, which is how I got the case. You're suing for $5,000 for false information in your credit report, not really giving the court any clarity as to what you're even suing for, which when it was transferred, and I'm assuming that could have been part of what the plaintiff or counter plaintiff is asking for. There should have been a more definite statement as to what you're suing for, so that they can know what it is that they need to defend against, or maybe work to try to resolve. And so I don't have that. B, there is a believe counter suit here, counter complaint that you've been served with, at least as we have it in our file, since October 3rd, 2023 is what it says here. And that information states that you were evicted in 2019 from the apartment complex in question, that there was a judgment that was entered then at the time of the illegal eviction. It says that the damages were sent to your last known address, that unpaid rent and damages totaled $835, and 37 cents, and that even after they applied your deposit, which they said was $250, that you still owed a balance of $585.87. And so we can't even move forward because at the last time you were here, you indicated you wanted to hire an attorney. You've not done that. If you're seeking to represent yourself, then that's fine. We can move forward that way because you're the one who filed this lawsuit, and I'm not going to postpone this any further. And so you're going to need to do some things. And one of those things is, first, you're going to have to make sure the plaintiff, the counter plaintiff slash defendant that you're suing knows what you're even suing about. And false information on your credit report is not sufficient of an explanation as to what you're suing about. What specifically did they put on your credit report that you're suing for? I need that in detailed writing more specifically. Okay, so if you're saying that they put a judgment on your credit for $585, well, then I need to see that in writing served to them so that they are put on notice as to what the basis of the lawsuit is. The other concern is you need to respond to their counter lawsuit. If you don't respond, then you're not disputing it. You're essentially agreeing when you don't respond to them. Okay, so you need to put your response to their counter lawsuit that you owe them money in writing. Okay, and I'm going to give you some time to do that. Counsel, I didn't know if you wanted to place create a record today.
Your Honor, I don't. The record that I was going to indicate, Your Honor, was simply that I believe this is hearing number 4. I think we were before you on October 10th, again October 28th, January 3rd, and now today. And I was going to indicate that, of course, no answer has been filed. We are. If the court is ordering a more definite statement, I assume that soon after receiving that statement, we'll be prepared to file a motion for summary on the underlying claim, perhaps as well as on our counter complaint. So I would just ask, ultimately my request today for the court was going to be to set this on track for trial so that we could file those motions and have a trial if necessary.
Okay, sounds good. So that's essentially what we're going to do. I'm going to give you 2 weeks, ma'am, to file a more definite statement, which is what I explained to you as to what is it exactly that you're suing for, and it can't be as broad as false information on my credit report. I don't know if there's false information in your credit report or not, but this doesn't tell me what it is or that they're responsible for it. So you need to address that, and then you should have received or should be in possession of a copy of their counter complaint. Do you have that, ma'am? Okay, we'll get you a copy as a courtesy today because you should have already been served a counter complaint. You need to respond to their counter complaint in writing, and you need to serve a copy of your response to the defendant's attorney, and you need to file a copy of that with the court. If you don't do these things that I'm telling you, at the next court date, I'm dismissing your case for failure to prosecute, meaning you're not moving the case forward. So I'm gonna give you an opportunity. I don't have a record here where we were here on October 10th, but maybe we were. I do have a note here that October 28th, that the plaintiff requested to hire an attorney. And so I reset it then for, it looks like I originally set it for the 3rd, or maybe I wrote the wrong date down. But I only have this as the second time. Okay.
You said that they served me, you said they served me with papers as far as the deposit and all that, when they did not, because I would have had.
Well, you're gonna put, this is not the time for you to explain all of that to me. You'll get what they said and you get to respond to it in writing, okay? So what they said was that they served you all that stuff. You're gonna get a copy of that. As soon as I hand her this file, you respond in writing with what you're gonna tell me, and that's what you're gonna serve to them. And you're gonna file a copy on the 5th floor with the court within the next 2 weeks, okay? And then I'm going to set a control date in 2 weeks to make sure that's done.
February 6th at 2.
Does February 6th at 2 p.m. work for you, council?
I believe so. Give me just one moment, Judge. Yeah, that'd be fine, Judge.
Okay, we'll set the next court date for February 6th at 2 p.m., okay?
And that's going to be set as as essentially a control date or a pretrial date, Your Honor?
We're gonna set as another pretrial date because
Got
we
it.
should have her answer filed by then. And her, more definite statement slash answer should be filed by then, and then the court knows better how to move forward. If we don't get a more definite statement slash answer, then the case will be dismissed for failure to prosecute. If we do get one, then we know how to move forward with setting any further motions, or if necessary, a bench or jury trial.
Understood. Okay.
Okay.
Thank you very much, Your Honor.
You're welcome. We'll get you a copy of this paperwork and the notice in just a moment. That's the writ. And here's the notice. And although you just so happy, you're all set, counsel. Thank you.
Thank you, Your Honor.
Good afternoon, Your Honor. This is Victoria Osborne. I just wanted to check in with you about LG Park Place LLC versus Scott, or I'm sorry, Scott Mallory.
We checking in about, I'm talking to someone right now.
Oh, I apologize.
I'll call the case in a moment. Okay, on the record, in the matter of LG Park Place LLC versus Scott Mallory, 24-07268. Council appearance.
Yes, good afternoon, Your Honor. Victoria Osborne for the plaintiff, LG Park Place LLC. And my apologies, Your Honor. I did not see you speaking with someone else. I was not trying to be rude.
I think she was out of the frame of the court camera, but yes, she was dropping off some motions and briefs and had a discussion. Let's see, this is supposed to be, but no issues. I think this is a motion to set aside dismissal. Do we have Scott Mallory here? Oh.
You are correct. It is my motion to set aside a dismissal.
I'm just reviewing your motion, okay. This was
Sure.
dismissed by judge. Let's see. So, did your office not appear in court?
Yes, Your Honor. My assistant called and I believe her name is Stephanie. The court clerk said that there weren't a lot of notes, but it appeared that there was a hearing and that we didn't appear. And of course, I freaked out because I didn't have it on my calendar. But I went back and looked through, I searched my email even for like a my file email, that comes through with the notice, and I could not find one for that date.
So there would have been a pre-trial, and then we would have given a hearing date. I do see a jury demand in here from December 11th. Did he pay for a jury demand?
So
What happened? They didn't set it for jury?
also at the exact same time, defendant had filed a request for a jury demand.
Yeah,
And
that's what I said. We filed a jury demand. Usually when that happens, they pull it off the docket.
okay. And I had also emailed, it was right before Christmas too, so I know things are a little crazy right around that time. But I had emailed to try to get a hearing date because the defendant filed the jury demand more than 5 days after.
I can't see any notes in here, but I don't think we see any notes in my file lately. Let's see. I'll give it a minute.
Jury demand was filed in December 11th, it looks like, and then.
When was it pre-trial?
The trial was started with 4.
The pre-trial was December 4th.
And I believe he filed
a jury demand on the 11th, okay, and then what else is happening here? They accepted his jury demand fee.
right, but it's more than 5 days past, and that's what the court rule says.
Yeah, well, the clerk's office accepted the fee. They shouldn't have done that, but they did.
That's why I wasn't really sure what the protocol was because I haven't run into this issue
Right.
before. But
and then on top of that, when they do that, they typically will just remove it off the docket because a jury demand was filed so that they could set it for a jury. And they didn't do that either. And so here we are. It looks like there was on the 18th, no one appeared from the plaintiff's side. And let's see.
One that I couldn't find notice on at all. And I had actually emailed.
That date. Well, the date would have been provided at the time of the pre-trial anyways, and then one should have been mailed. And I think in our system, it said it was mailed. Let's see, complaint service. What's this for? Maybe not. Notice to appear is not for this.
I don't think I can do it.
I don't see that a notice was mailed.
Yeah, like I
Either
said,
way.
I went through my emails.
Yeah, it seems like there's multiple issues going on here. Um,
And honestly, this is just a holdover. Like the girl's not even on the lease. It's just a squatter we're trying to get out.
well, they failed to appear today. There was multiple issues, meaning they shouldn't have allowed or accepted a jury fee after the statutory time frame. Then, once they did that, that should have triggered a jury trial date going out, pulling the hearing date as well. That didn't happen. And then I don't see where at the pretrial a notice.
I scheduled it. I just didn't
Oh.
print it.
Okay, I don't see where a notice went out, or was even printed to go out. So, the motion, to set aside the dismissal is granted. The other issue is that the defendant has failed to appear today, and so did you want to default?
Yes, Your Honor. I'm not exactly sure how that works in this situation. Is it just a default landlord-tenant judgment for possession?
That is correct. But
Okay.
we can set
Yep.
for a hearing. I don't know how it was filed. Was it for money? Let me see.
No, because it's only it's a squatter, so there is no lease. And we honestly, we don't even know her name, so I'm not really sure how we would collect from her. So we just filed for possession, I believe.
So it's not actually Scott Mallory that was living there.
No, apparently he moved out and left other people there.
Wonderful.
Hmm.
Okay, if you could provide an order to set aside, granting the set aside of the dismissal and an entry of default.
Okay, Your Honor, would you like a separate order and then a separate default judgment? Or can I add the order to
You can
set
add it
up?
all to- It could be one order, that's fine.
Okay, onto the judgment would be okay in that blank spot?
Yes, yes, indeed, that's fine.
Okay, thank you, Your Honor. I'll submit that via my file.
No problem. Okay, any additional matters for the record?
No, Your Honor.
Yeah, okay, you're all set.
Thank you. Have a great day.
Same to you. I don't know why it doesn't show me any of the previous notes. Let's see. Okay, so when I go, let's put a note in here. I should be able to view the case note and see it in there. But I see nothing.
Let's see.
This is the matter of Discover Bank versus Thomas Blanchard, 24-07574. Council appearance, please.
Good afternoon, Your Honor. For the record, William Saloom, P41487, appearing on behalf of plaintiff.
Okay, and I don't see anyone present or on behalf of Thomas Blanchard. No one's in the hallway. No one's in the hallway, Yolanda? Hello, Yolanda?
I'm sorry.
No one's in the hallway?
No.
Okay, my apologies. This is a matter set for a pre-trial for a general civil. Did you want default to enter, counsel?
Yes, Your Honor. Defendant in his answer didn't deny the debt, and I think he indicated he had a debt company trying to resolve his debts, although we haven't heard from the debt company or him. So, but in any event, yeah, I guess it default. And you want us to submit a judgment under the 7-day rule?
Yes, please, and thank you.
No, thank you, Your Honor. We'll do that.
Thank you. Any additional matters for the record?
No, Your Honor. Thank you. Have a good
Thank you,
day.
Your Honor. Same to you.
Thank you very much.
are ready to go on the record on this. This is Sparrow Hospital versus Majidula Guasidin 24-03003 GC. Appearance for the record, please.
Yes, Your Honor. Michelle DeGraff appearing on behalf of plaintiff, P number 88041.
Your name,
Majidullah Kristen.
and we have an interpreter. Your name,
Yes, Mahbuba Khida,
can you spell it?
Mahbuba, and last name Fidba.
Thank you. Raise your right hand. Do you solemnly swear or affirm to interpret in the matter before the court completely and accurately and not divulge confidential communication?
I do, Your Honor.
Thank you. Today was the date that was scheduled for pretrial.
The public
The parties met. Counsel, did you all complete the joint pretrial statement?
Yes, Your Honor. I sent it back to Miss Addie Nash via email.
Oh, right.
We're just waiting to see give it time for the email to come through. Someone online said sue everybody. No. Is that it? No.
Your Honor, we can sit.
Oh, you can sit, yes. We're printing the paperwork now. Thank you. Okay, I do have a pretrial statement here. The breach of contract. A defendant claims insurance responsible. The pleadings are in order. There's no admissions to fact, well, there's gonna be exhibits filed separately. And do you understand, sir, what discovery is?
I don't know.
So discovery is the time for you to get documents or other information from the plaintiff or for them to get it from you. So if you need a copy of the billing records or maybe whatever information you gave at the time of your appointment, you could submit a request during discovery to do that.
I provide my email to to them, and I don't know, she promised to send me all the bills. Details
bills?
of the bills there, because he doesn't have a copy of the bill.
Request them.
Yeah, he requested to send it to him, because he thought that is, he didn't know that's the bill, he says, I thought it's a receipt that they charged the insurance. We never paid it, since the insurance.
Okay, so the defendant requested copies of the bills to be sent via email, counsel?
Yes, Your Honor, I have his email. We went over it in the breakout room to be sure I have it correctly. And I have a note to send him the itemization, and I have some consent forms that were signed on that
Okay, very
day of treatment. So I told him I would send both of those.
بيلاحظ برمضات من ماما بلا هم أتمان سمكان كده بس شبكة عندهم مش مكان.
Says he can send sign.
What's the consent sign? To sign consent?
It's the medical consent forms.
Yeah, تمو بلت وقت يوجد هذا خلاص كتبنا شو قانون يجي something كنا كنا consent برد شيء شو مرة جدًا شيء. Okay.
You have any other requests at this time, George?
Not yet on it.
Okay, and so discovery period or your time frame to ask for any further documents will be over after the 23rd of March.
بدل بس same much بدل بيجش much the first time أنا ما كان شيء كذا ما كان تاني وقت برين في بخانة جوا سبير ما شيء مثلا. Accept the bills. I don't want anything from them to because.
That's fine. If something comes to him, he can still ask for it, okay?
Yeah, كلام شيء عمل لكن بقول مثلا
Because the cutoff date is going for discovery is March 23rd, I'm going to change the date that you have for motions to April 23rd, because that'll be the deadline to file any motions for summary.
هيك منو مرتقى ذكر ما بستشار يعني بستسافر شو مثلا في وقت مش ما متشغلة بس.
Says that it's knowledge. not special سوال میکنن چیز چیزایی ضرورت داشته باشه طریقه ولی یا زنگ میزنه.
So he's asking if you need something from him, you're gonna email him or you're gonna call him, how you get the information to him, if you need something from him.
If they want discovery, they'll serve you with discovery. Typically by mail.
Yes, Your Honor.
Yeah, if you need something, you also can call me something because he doesn't read English. It's harder for him to read it, but he can speak some English and he cannot read and write in English.
But that they have to follow the court rules. So if they serve you with discovery, if you get something from the court or from them, you need to get an interpreter to read it for you, okay?
But no procedure محكمة تدريس كنا أجر أزنا يا خاتم يعني المحكمة خاتم جدا بركات بتن برتن ترجمة كنا قانون عملت بس كثير روان كنا مش مو بركات بتن أرشد كميرين وبركات إن شاء الله بتن برتن ترجمة كنا. Says, yeah, I understood that they could call me or not.
No, it's going to be in writing. He has to respond in writing.
Yeah, maybe باخد تنبأ كاتبي جواب بتي. Actually, ما كاتبي جواب مثلا. يا كسر فايدة كنا ترجمة كنا. Find somebody to translate.
It's very unlikely that there will be any real discovery in this matter. Correct, counsel?
Yeah, it would essentially be asking what documentation he would have to support his claim.
Yeah, maybe I'm sure for some from which is another can million dollars. Don't want to be
And typically a request for a simple request for admission.
Yeah, only the document I have that I have a Medicaid at that time I can send a copy of Medicaid. Yeah, I already provided to you guys.
Okay.
Yeah.
They may send what's called request to admit, a request for admissions. They may send what's
Okay.
called request for admissions.
Yeah, make sure that दोबारा शो तक खोजो करके दोबारा round. Okay.
I'm gonna put it on the record now. He is unrepresented and there's a language barrier, so I'm not likely to deem them as admitted if he doesn't respond.
Okay.
يعني ممكن كان شما شو زبان نام خوانا كلام شيء كلام تأخير مش होती نام خوانا لكن كلام مثلا مختلف كون ولا بنسبة.
Okay,
Thank you so much.
no problem. We do have, let's see, damages, $1,518 plus cost and fees, correct?
मैं तखुदा करी अगर तो $500 जामे फिर वो जगह में फर्क शामिल.
Right, counsel?
Yes, I apologize, Your Honor. I
No
couple different
problem.
voices going. Yes.
No worries. Then expert witness, it says to be filed separately, but I don't know that there's one needed for this.
No, Your Honor. My brain was thinking of just witnesses. We would typically file something, saying that the records keeper of the provider might be called as a witness. But yes, we would not need an expert witness.
هنا شايلك متخصص باشه متخصص باشه من وقت تمام توجد لك مستنام
Okay. I'm also gonna require that you bring up physical copies of your exhibits at the time of trial.
He Frank or
For any exhibits that you want to admit, you gotta bring a copy of your exhibits at trial.
Archie recommend that ما تبقى نشان بكن عمره سوى كوفي شوب فلازم بتيجي أنا سأنا كده دورنا جوا عمره بشان يا هذا شافنا
And then we have a bench trial about a couple of hours, correct?
Yes, Your Honor.
It'll be set after April 23rd, 2025. You'll get the date in the mail, and I'm gonna have you sign this document. Thank you. Okay, do you have any questions today, sir?
Thank you, Your Honor.
No problem. Any additional matters for the record, counsel?
No, thank you, Your Honor.
Thank you. You're all set.
Thank you.
Thank you. We can give them a copy of that.